if there's a felony situation, then you just can't be guardian, just period. If a person is a family member, then that person can be a guardian from wherever. It doesn't have to be within the state of Florida necessarily. As long as they are connected by what's called lineal consanguinity, then we've got a good stage for a guardianship. However, if a person is not family and not living in Florida, then they just can't be guardian. But they can be not family and living in Florida.
What's the definition of family?
Family is going to be of the ward, so we've got to look at the family of the ward, and if they're connected by blood or marriage. So, you know, if even adoption counts as family in that situation.
Okay, so my stepfather, so not marriage.
By marriage, that's correct. So yes.
If my mom were to pass, would that still hold?
Yes, it would. Yeah. So that line does still continue on there. And so then what we have next is, of course, you've got to apply, you've got to petition to become guardian, and then there are certain background checks and other investigations that would still have to be done. However, this is where having an attorney is helpful, because we can petition the court to waive some of these things if we can see that there's no need to do that. In a guardian advocate situation, we often waive some of these background checks because you're the parent of the child. We're presuming that you have, you know, your child's best interests in mind. But the education requirement is usually not waived. We may waive it in certain instances. There's always going to be, and I may get into this on another slide, but there's always going to be certain accountings and other information that's provided to the court on an annual basis. We can waive the accountings if we can see that there's no assets, if the person is not receiving any income other than Social Security, then we waive the accounting requirements. But the guardianship plan is always going to have to be done, and we'll probably get into that next there. So again, you know, you can do this on your own. I just don't recommend that. So again, when are we going to start this process? You don't necessarily have to start it if your child is 10 years old, but it's going to be something you want to think about and then be planning for that. We can say that generally between 17 and 18, then that's a good time to really get this process in place. Because it does take time for us to petition the court, to get a hearing date, to get all the people involved that are necessary to get involved, and then to then do this. Thankfully, since COVID, we step into the courtroom a lot less than we used to. And so we can do all of these hearings remotely. And so that's sometimes very helpful for the families. It's really nice, especially when we have some kids that may have some pressures of being afraid of being in a place like a courthouse. We have the parents at home with the kids doing this. And and the judge in this case likes to see the child, and sometimes they'll just have some banter with them and whatnot, and it's kind of a nice situation there. In certain other kinds of hearings that we deal with for custody and whatnot, then in those situations a child is not even allowed in the courthouse, other than the courtroom. So guardianship is kind of nice in that way there. Again, the standby guardian can be done anytime, and the emergency, temporaries, and plenary guardianship are going to be generally, again, going to be for individuals that are over 18, and we need to do guardianships kind of in full for those situations at that time. So, how much is it going to cost you, right? And so, there are some of these, as I think it works. So, when we do a guardian advocate, typically the ward, your children are going to be determined to be indigent. This is going to save a lot of money in this process. If we have to do a guardianship that is not a guardian advocate, then it gets a lot more expensive really fast. But when we do a guardianship advocate, then you're basically not going to have to cover the filing fees. And then you won't have to cover the LSOR or the other court-appointed attorney fees because the state is gonna cover all of those things under a guardian advocacy. And then there are annual costs. So basically the court, if we have to do some annual accountings, then that's gonna be certain audit fees that are gonna be covered, not covered, and you've gotta cover that. And then there will still be typical attorney fees for an annual plan, where we basically will be getting from you, and we will remind you to get a physician's letter every year that says that you've taken your child to the doctor, that this is kind of what's going on, have a social plan, all of these things go into the annual plan, and then we submit that to the court. And I, of course, review it ahead of time and whatnot. So there are typical attorney's fees that you'll have to kind of budget for as part of that process.
Because in private schooling, when a child turns 18, we can't talk about grades, we can't talk about academics. The child can leave the premises, get an Uber, get a Lyft, and there's nothing that the administrators of the school can do. So just to keep everyone in the loop on that. So the prior to 18, when you're looking in an educational standpoint, is very, very important. Because at that point, they're a legal adult. And without any type of guardianship documentation, that kid can come and go as they please. So it's just something to think about as a private school and public school. Public school is the same thing. As soon as they turn 18, they can sign themselves in, they can sign themselves out. So it's just something to think about.
But he got contacted by a young lady on Facebook that then befriended him, and he's in his mid-80s, and she is allegedly in her maybe 30s or so, and he firmly believes that she is in love with him, and that all these other good things are going to happen, even though he's invited her to come visit several times, and somehow that's never quite come about. And so we had to go, and in fact, in this case, I'm representing him as the LSOR, and the family has their other attorney that is bringing everything to court, and we've got to take certain rights away from him because he's just not making the right kind of decisions and is open to exploitation. So there's three key words that we look for in guardianship overall. It's going to be abuse, exploitation, and neglect. If those are kind of some of the situations that are going on, then that's where guardianship is going to come in. And we sometimes have to do an emergency temporary guardianship if that is going to be even more of a situation. There's other reasons for a guardianship, and I can tell you stories all night for that. Waived. The annual accounting can be waived if the individual, the ward, or the child is not going to be receiving any sort of funds other than Social Security or Medicaid benefits, then that's something that can be waived. If, however, the person has some paying job, some income of some sorts, and they're relatively high functioning, and may have some bank account or even have a condo in their name or other things like that in place, they're not indigent, and then we have to do the annual accounting for that scenario there. So, we've had some situations where some parents thought they could handle their child that had certain psychological challenges, and then unfortunately because of that, then we had to go into a lot of guardianship and other legal issues for that, and because they had bought a condo for them thinking they could live in there and everything else, then it became more financially challenging for the whole process. So before you think about what you're going to do and do it, talk to an attorney ahead of time to make sure that it's the right. Okay. So any other guardianship questions before we move on to how to help care for your kid's financial future?
I just thought about when you were talking about the exploitation part. Even our kids that are here in this building that are high school, junior high, they are automatically getting like credit card applications in their names. So my red flags went off, especially for our higher functioning kids. how many credit card offers right when they turn 18 do they get? And then they don't understand the impact. It's like, oh, they just gave me $5,000. The next thing you know, oh, well, they don't, it's that step. So
Sure.
it's just something else besides just thinking of the basic, oh, need and take care of and medical situation, but the exploitation, especially in this world today.
Financial challenges. A guardianship case that I just took on, not a guardian advocate, but a proper guardianship husband for his wife due to alcohol-related dementia. And she had a gambling problem and also a credit card problem. And and the husband and the daughter are co-guardians for the wife, and they're still digging up credit cards that and other accounts that she kind of hid away, and you know, has been very challenging. He's actually he had to have the wife go to a certain place, and he's living with the daughter because they had to give up their house, for example, as part of the whole process. So it can become very challenging there. Do you have a question?
Well, I actually trying to do as much preventative as I can. I actually
Started guardianship in Brevard County, for example, or down in Broward County. Then if you move, or if the ward moves, then the guardianship will stay in place if it is a contingent county. But beyond that, then we needed to transfer the guardianship to the new county, to within Florida or elsewhere. So we can domesticate from a foreign county or a foreign state into Florida or into Brevard County, but it is a process because we have to get that file closed out there. We've got to then have the whole file actually transmitted to Brevard, and it has to be reopened under a whole new guardianship case. So it can be a bit of an annoyance, but it must be done. If you move, guardianship is one of those things that is not automatic. You have to actually take that and make actual physical petitions for the new guardianship. About supplemental needs trusts, most of you have probably heard about supplemental needs trust. Anybody who's not? Okay.
No, I know. I got an eyeball raising.
Yeah.
Oh my God.
So we'll talk about different kinds of supplemental needs trusts. We're also going to talk about the ABLE account, and I think the ABLE account is pretty cool. And I'll tell you some things that's good about it, and some things that are a bit of a con about it. So, a self-settled supplemental needs trust, also known as a special needs trust. So we've kind of changed the terminology to supplemental needs, but it's still special needs trusts. And D4A is actually a reference to the IRS code that actually generated all this. But a self-settled supplemental needs trust is something that is done by an individual themselves as a special kind of trust. So let's say, I were to be disabled to some degree. Doesn't have to be physical disability or mental disability, but then I get an inheritance, and then that money is already in my name. That's actually the most important part, that it's come to me already. Then we would have to do a self-settled supplemental needs trust, which is a first party. That's the me part. And so then this basically is going to be kind of some of the terms for that. So if it has to be under the age of 65 for a supplemental needs trust, has to be for a person that is disabled, and the self-settled part is kind of self-explanatory. It has to be done by the disabled person for their own assets. And then basically, then a supplemental needs trust overall is a kind of trust where somebody else is acting on the person's behalf. So if somebody else is what's called the trustee, and then that trustee is going to be making all the financial decisions for you when you do the first party supplemental needs trust. Okay? Really kind of a little terminology point here is to supplement and not supplant government benefits or public benefits. So the point of a supplemental needs trust is to cover things that the government benefits don't cover. So if a person is getting SSI, for example, or other Social Security or Medicaid or government benefits, then there's going to be basic, shelter, food, and clothing coverage, but for other things like a car, like utilities, like internet, like a cell phone, all these other expenses that are going to be in addition to supplementing whatever the public benefits are, that's the point of the supplemental needs trust, okay? Not to supplant any benefits that are already being received. That's kind of the whole point, is that you want to maintain those government benefits then.
Excuse me. You expand on.
So here we're just gonna be wrapping up the talk, so if you have other questions, this is a good time to kind of start thinking about those. If you have a child or minor that you're caring for that is reaching 18, really important for you to consider guardianship. If you've not done your own estate planning at this point, then you should be able to do that. And when I talk about estate planning, and we talked about this a little earlier with one individual here, some people say, well, I don't have an estate, I don't have anything. Why do I need to do my own estate planning? It's not just what's going to happen with all your stuff when you die. It's also who's going to be making the legal, financial, medical decisions for you when you may be incapacitated. And nobody has a crystal ball, mine's in the shop at least, to know when that is going to happen. And so having your own estate planning is going to be a really good first step to make sure you have all these things done. And it's kind of thoughtful for you to do if you have children that are going to need other assistance later on.